Okay, hello everybody. Thanks for logging on and listening to this. We'll get straight to it. You can see who we are, Bridge Employment Law Specialist and HR Specialist. Just a quick intro. So I'm Lee Stevens, a director in the team, Specialist Employment Law Solicitor with 25 plus years experience.
Sean Pinchbeck, solicitor at Bridge, and I've been in employment law 35 years now.
I'm David Rogers. I'm a director and solicitor at Bridge, employment law specialist as well, with 25 years experience.
Yeah, so you can add that up if you like, but it's a lot of years. So what we're going to do now is have a discussion together, a presentation, bit of a discussion on this particular area, which we think is very useful for all our clients and prospective clients, companies, company owners, SMEs, anyone who is building, developing, running a business that has information in it that its employees can access. So title of the presentation is Protecting Your Business Critical Information in Employment Law. And what we're going to look at specifically is who should we consider protecting information from? Okay, so we're going to walk you through that. What types of information can be protected? And you're going to be thinking about that in the context of your own business, and we'll try and give examples for you as well. What legal tools can we use to protect information outside the contract and within the contract? We'll see when people are employed with us and when they leave our employment as well. And what legal tools can we use to restrict competition post-employment? And then we'll go through a scenario as well. Little typo on that slide that I've noticed, but hopefully you'll ignore that. Right, on to the next slide. So David's going to kick off with protection from who and some real life examples.
Yeah, so the first question is, what are we looking to prevent? And essentially what we're looking at is misappropriation of business critical information by competitors, really. That's really what it comes down to in terms of the concern that we're looking to address. And the question on the slide is protection from who? And the first category to look at in that sense is employees. In particular, I think what businesses are mainly concerned with here is customer-facing employees. So sales staff are an obvious one because they have contact with your customers and they're the ones that develop the relationships and are in a position to potentially damage your business if they take those customers with them. Employees, whilst we're going to deal with that first of all because it's an obvious concern, it doesn't tend to be the main issue when we're looking at this issue of business critical information and who you're protecting it from, because you do have quite a significant degree of control over your existing employees. And in the absence of somebody setting up a side business, which does happen from time to time, we've all had cases where it's happened, where somebody sets up a business on the side and is actually brazenly competing with your business whilst they're still employed. It does happen from time to time. It's not particularly common for obvious reasons. So in terms of employees, we need to be concerned with obviously sales staff, as I've already mentioned. Other categories, an obvious one would be anybody involved in product development, innovation, research and development, because they've got access to highly confidential information, which can obviously be damaging to your business if it falls into the hands of competitors. So we do need to keep an eye on employees, but probably the main category of concern is former employees. So because they're the ones that can really damage your business by either joining a competitor or setting up in competition themselves. So former employees are the ones that we need to be particularly concerned with in the categories that I've already mentioned. And the way to look at it really is to look at employees and think, well, who was in a position to, what knowledge and information do they have, what relationships do they have, and how could they damage our business if they were to go either to a competitor or to join or to set up in competition themselves. Another category that we need to look at, consultants, self-employed people that you do business with. It's not as obvious, but they often are people who are in a position to do significant damage to your business because of the access that they have when they come into your business. Thinking of categories like IT consultants, website developers, they're often given carte blanche to look at everything in the business so that they can do the jobs and provide the advice and build the systems that you need. But they do have access to a lot of confidential information, often including your entire customer database. And what you also need to consider with consultants and self-employed people like that is that they're often working for your competitors as well. They'll do a job for you, and then the next week or the next month they'll be down the road doing a job for a competitor. So you do need to be careful that you protect the information that they have access to. So that's a category that's often overlooked, and one that needs to be considered quite carefully. So I think those are the main categories. Agency workers are another one, obviously, because they're not your employees.
They're often overlooked as well.
Yeah, they're often overlooked for that reason, because they're not directly employed by you. But again, they've got access very often to exactly the same information all your employees have got access to. And whilst your employees will normally have contracts and various provisions in there, which Sean will come on to talk about later, agency workers won't have that. So you need to think about how you protect that as well. So I think those are the main categories.
Yeah, and you can have some, like we've talked about this before, haven't we, where some clients who engage sort of consultants and agency workers have sought to have some sort of standard agreement that somebody signs when they come in. Potentially some confidentiality agreement incorporated into the process of coming on board, because the agency will often provide some standard terms for an agency agency worker deployed into your business. But that often means in the process of bringing someone in, it's completely overlooked. Confidentiality, access to information. And as David said, we've all seen, I think, here where consultants or agency senior people or specialist people have gone in and had access to all sorts of information. And either there hasn't been an issue, sometimes there has, and they've realized, gosh, actually, because we engage them in this less sort of a standard way, we haven't got any protection at all. So definitely worth looking at. There's some. So shall I move on, David?
I can move on from that.
Okay. Then we'll go on to the next slide. So David's just going to run through. I think this probably covers a bit already.
We've probably already touched on it. This is really just dealing with the types of information that you're looking to protect generally, and that we're going to be considering in the course of this presentation. So I've already touched on some of them. Obviously, customer contact details is an obvious one. Supplier contact details, again, that's can be business critical very often. And financial information, so pricing margins in relation to your customers and your suppliers, again, is very useful information to competitors. And I've touched on the other one as well, the other main one, product specifications, processes, trade secrets. So it tends to be more appropriate to manufacturers and people with dealing with secret formulas and processes, but also business plans, strategies, margins, finances, and data and systems are all things that can be of significant use to a competitor and can damage your business if they fall into competitors' hands. So those are the main sort of areas that we're going to be looking at. Yeah,
so that sets the scene, and what Sean will flag as well is how the awful graphics that I've used there, that contain these subjects, as we'll all stress later, those subjects are in principle protectable, but the nature and level and degree of sensitivity will dictate whether they are or not. And it's going to be quite, as you'll see, it's quite tricky to get that right. You know, what you're going to label, that Sean's going to go through, may not actually be protectable post-employment, or maybe, depending on the nature of the information. We're going to examine that now. Sean's going to go through that for us.
Okay, so the slide refers to the types of information that you can protect. And the answer to that, in one word, is confidential. So what type of information can you protect? The answer is confidential information. And you've just seen some examples of it. And if you want to put it in extremely simple terms, you could say that it is really information which your employees know because they are employed by you. It's not information that you would put on your website and the public would be able to access anyway. So that's what you're looking to protect. And what the slide asks is, what are the differences between them? And what is the relevance to you? Can some information be more confidential than other information? And is it therefore better protected in law? And the answer to that is yes. And there is one particularly crucial type of confidential information which has greater protection in law, and that is what is known as a trade secret. So it's important to think of a trade secret as just an example of confidential information. But if you like, it's the king of the confidential, it's the Messi of the, to use a football terminology, it's the Messi of the world of confidential information. It's right at the top there, and the law provides better protection. So what is the relevance to you in establishing whether information which you believe is confidential is actually so confidential as to constitute a trade secret? And the reason that it's of significance is that the law provides protection for confidential information while the employee is employed by you, but not after. Whereas if that confidential information is so confidential as to constitute a trade secret, then it is protected after the employee leaves as well. So you can see that it is significant to be able to identify whether something is so confidential as to be a trade secret. So that raises the obvious next question. Okay, well, what is a trade secret then? And is it defined in law? And the answer is that it is defined in law and has been since 2018. And it is defined in Regulation 2 of the Trade Secrets Regulations. And I've no alternative in order to answer the question, what is a trade secret, I'm afraid, but to provide the definition to you. But it is extremely convoluted, and I will be providing a translation into normal English once I've provided the definition. So this is what a trade secret is. It is confidential information, reminding you, I've already said, that's what it is. It's got to be confidential information. But what makes it a trade secret is, firstly, it is secret in the sense that it is not, as a body or in the precise configuration and assembly of its components, generally known among or readily accessible to persons within the circles that normally deal with the kind of information in question. Obviously, very clear. Perhaps you may think not. So I'll seek to go back to that to explain what it actually means. Fortunately, the next two requirements are more simple. So the other requirement, the second requirement, is it has to have commercial value because it is secret. And the third, which I think is quite linked to the second, is it has to have been subject to reasonable steps under the circumstances by the person lawfully in control of the information to keep it secret. So first of all, it has to be secret, and as a result of being secret, it has commercial value. So some sort of recipe that is secret would have commercial value, because if the employee was to leave and take that recipe to a competitor, you wouldn't be happy. Has it been subject to reasonable steps by the person lawfully in control of the information to keep it secret? In other words, has the business actually tried to keep it secret? Or is it gossiped about in the canteen? And in reality, people know this recipe. It's not limited to a few people. So there has to be evidence from the company's perspective that it's emphasized just how crucial it is to keep this secret, only known by a few people. So I think the second two are relatively clear cut, but going back to the first one, which is very, very badly worded in my opinion, I think what it is actually driving at is that even people who work in the specific field, manufacture of a product, for example, even though they're in the circles normally dealing with that kind of information, they wouldn't actually know. So going back to the recipe point, there may be other companies producing recipes, but not exactly the same. So even though they're in that field of work, they still don't know the assembly of the components. They don't know exactly what goes in to make the end product, even though this is they're in the circles that work in that field. So I hope that gives you an understanding of what I think that very convoluted wording actually means. So it gets across just how crucial it is to distinguish and ascertain whether or not it's a trade secret.
And practically, Sean, is that in terms of clients' management of information? How does that apply then? Is that a case of making sure?
Well, I'll come on to what you can do about this, but I think the answer is that if you believe that something is a trade secret, you need to spell it out. So you need to put it in the contract that you have access to information which is confidential, including a trade secret. And you may want to give examples of what they are, so that the employee can't say, well, I didn't actually realize that it was a trade secret. So I didn't realize that I couldn't reveal it after I left you. So I think that's what you would have to do. You would spell it out.
And then manage that information very carefully internally.
Exactly. Make clear that even other employees are not allowed to know it. It's only the people who have to know it, who are actually working at the coal face, if you like, of this recipe, who need to know. No one else needs to know. So not covering IP, because that's a specific area of law which generally requires an IP lawyer. So the next slide is, how can you use the law to protect your information? So it's important not to be confused about what this is about. This isn't about what you can do yourselves contractually, which I'm going to come on to. This is about, does the law actually provide some protection for you? And there are some forms of protection that the law provides. So even if, which would not be a good thing, but even if you're in a position where you either haven't got a contract with an employee, or you have, but you haven't got either any or adequate clauses relating to confidential information, does that mean, well, there's nothing you can do? Or is there some degree to which you can rely on the law? And the answer is, firstly, during employment, the law provides some protection to businesses. The first form of protection is a general one, which is that there is an implied duty of loyalty and good faith that the employee owes to the employer. And it could therefore be argued that they breach that if they reveal confidential information. There is also an implied term that confidential information should be kept confidential. Again, I do stress, I'm not recommending that you rely on the law here, but that is the answer to the question as to whether the law could be used at all by you. It could, but it isn't on its own good enough generally. And then what about after the employment ends? Well, the duty of loyalty and good faith does not continue after the employment ends. It only applies while the employee is employed by you. So you couldn't make any use of that. The only way that you would really be able to use the law after the employment ends is if the confidential information is a trade secret. Because as already explained, the law protects the trade secrets even after the employment has ended. So there's limited use that the law provides, which leads then on to the next slide, which is how can you protect the information? We've already established it would be far better for you to be proactive and not just rely on the law. So what can you do? And the answer is, the key is your contract of employment with the employee. That is your chance to set out exactly what the provisions are, the obligations on the employee to treat information as confidential, setting out examples so that the employee isn't under any illusions as to what it is they can and can't do. So you list the information that needs to be protected, explain that there is a legal obligation to keep it confidential, and make clear the consequences of breach, which, in my opinion, should spell out very clearly that a possible consequence of a breach could be a dismissal for gross misconduct. You can't go so far as to say it will be, but you could certainly say that it is a possible consequence of breach. That should get across to the employee how serious it is. And this needs to be incorporated into your contracts. And you need to stress within the contracts how important it is to limit sharing of information, even if it is applicable, which it will be if it's a trade secret, within the workforce itself.
Yeah, it's important very briefly, if you don't mind as well, Sean, just to add that, as we'll talk later, listing the information, getting this part of your contract right is a part of the basis for the restrictions that you can draft expressly that are enforceable after people leave as well. And it all has to be done quite carefully. And one thing I just want to get in here, which we all, I think, agree on, is there's a sort of often trotted out sort of view on these things, and particularly the post-termination restrictions out there. Well, they're not enforceable, is often said by clients to us, and all three of us have enforced them. So this is worth doing. It is worth considering all of this. We're giving you a very summary high level of this, but what we do with a lot of our clients is work through, when you're appointing a new director, a new senior exec or person who's coming in, who's going to have access to a lot of information, is we'll go through with you. And it's a fairly straightforward process for us with the client, but we'll go through with you and identify the types of information, get that set out properly in the terms from the off as part of the offer of the role or the start of the role or the promotion, and then build that into the post-termination restrictions, which we'll talk about later. So again, we're talking a little bit in the abstract, which Sean has to do because it's quite complicated stuff, some of this, and we're trying to make it as straightforward as possible. But it has real world material impact on your business if you get it wrong. It's not the case that a sort of a go at this by someone internally usually creates something that's enforceable. It needs to be drafted by a lawyer, just like if I tried to do some of the things that my clients do, I don't think the outcome will be particularly good either. I'm not an expert in those areas. So I'll get off my soapbox and pass you back to Sean.
Yeah, I mean, I think the only other thing to add is that it is important to keep these things under review.
Yeah.
Because you can find a situation where an employee is issued a contract on the basis that they're admin support, for example. They don't necessarily have access to a lot of confidential information. Over time, they're promoted, particularly if they're promoted into a sales role, and suddenly they have all customer contact, they know all about the pricing, they know all about the marketing, but actually they signed a contract when they were 19 starting in admin, and it didn't really cover what it now needs to cover. And the times that people, unfortunately, employers forget that sometimes you need to provide a fresh contract, which is easy to do because you're invariably giving a pay rise. So it's not difficult to get the employee to sign it because they normally want the pay rise. But that's really important to keep it in mind, keep under review, that you can't say, well, I've got a contract for blogs.
Yeah.
But is it still up to date for blogs? And if we better make sure it is. And that's the way to do it. So that's very, very important.
Yeah, clients often get caught out with that, don't they? Yeah, absolutely. It's a good point. Shall I move on to the next slide? Yeah, that's over to David. So this is how can you protect your information continued. David's just going to provide a quick summary of wider tools used to protect.
Yeah, this is really just picking up from where Sean left off. Obviously, Sean's been focusing more on the things you can do contractually to protect the position of the business. So there's a few sort of wider areas we can look at though, which provide protection over and above contractual provisions, and that's really what this slide is focusing on. So first one on the slide is database protection rights. And in relation to this, additional protection is available for databases in certain circumstances. And it's essentially because the law recognises that a lot of time and effort has often gone into producing databases and information that employers hold. And in provided the definition is met, and I'll come on to the definition in a minute, additional protection can be provided, because essentially the law recognises that there can be what amounts to proprietary interest in that information if it meets the definition of a database, and the definition is provided under the Copyright and Rights in Database Regulations 1997. Again, it's a fairly technical definition, but it's probably worth reading it out. It's not quite as technical as Sean's definition of a trade secret, but it's still worth just having a look at it. And under the actual regulations, a database is defined as a collection of independent works, data, or other materials which are arranged in a systematic or methodical way and individually accessible by electronic or other means. So it doesn't have to be often nowadays it will be an electronic database, but it doesn't have to be. And this is the key bit, really, I think, of the definition, is where there has been substantial investment in obtaining, verifying, or presenting the contents of the database, the owner of the database will have a database right. So it's really talking about the investment in putting it together, really. It's not necessarily an investment in what it's made up of. It's putting the thing together into a database, into a useful tool that a business makes use of, and is obviously of significant use if it falls into the wrong hands. Customer database is an obvious example of that, and we've all come across cases where former employees, just before they leave, have essentially downloaded a database of customer contacts and taken it with them with a view to either giving it to a competitor or using it themselves. And that's an obvious example that would fall foul of these regulations.
You can track that, can't you, as well? You've mentioned before, David, there are tools you can actually track what they've done and find that they've done it and use that again.
Absolutely, yeah. There's things you can put in place which we can come on to in terms of protecting the business from that type of misuse of its information. So, and obviously, in terms of remedies, similar sort of remedies to what you would get under if you were successfully enforcing restrictive covenants, but probably more powerful in some ways, because you don't have to, provided you can establish you've got a database right and they've breached it, then you can get the usual sort of remedies such as injunctions preventing them from making use of that information, and obviously delivering up the information to you. You can get search orders, you can pursue them for damages and accounts of profits and the various things that we're familiar with, but it's often easier to do under, so it's worth looking at, because you may not have adequate contractual provision, but you may be able to fall back on this. So it's definitely a significant,
very powerful and quite scary for the employee, isn't it? Because it could potentially have criminal
because essentially it's treated as theft of property, essentially. So it's because you've got proprietary rights if you can establish that you meet the definition that I went through before. So it's definitely worth looking at.
We'd often look at that, wouldn't we, as well, when the client perhaps hasn't prepared the right provisions.
Yes.
And part of I know you've done that as well, David, before, part of the research with the client and the sort of recce of the case, say often a common scenario is someone calls us, and as you said, I think they've taken some of our information.
Yes.
We're permitted then, subject to certain justifications, to going in, searching, and the tools we can use can potentially find what they've done. If you can do that, then you have this extra recourse outside of the contract, don't you? Which is really powerful. Yeah.
So always worth looking at if that's the type of issue, if that's the information that you're concerned about. Somebody has walked off with information stored in a database. So moving on to the next provision on the slide, it talks about GDPR. So this is really looking at confidential information, which also contains personal data, which often it will do, from which individuals can be identified. So in that scenario, if an employee, a former employee, or a consultant, whoever it might be, has walked off with that type of information, then there may also be potential criminal liability under Section 170 of the Data Protection Act 2018. So that, again, can be a very useful tool. If you don't necessarily have to use it in terms of going down that route, but just the threat of potentially going down that route can be very useful for getting the information back quickly and making sure that the infringer doesn't make use of it. So because the prospect of being interviewed under caution by the ICO is not a pleasant one for anybody, and the potential criminal liability that may follow. So often the threat is enough to get your information back without it being misused. So again, that's another thing that's worth looking at. And I think the next thing we've got on the slide is internal systems that can be used to protect and secure data. Labeling is mentioned, so sounds obvious, but people don't do it very often. Label things properly, make it clear that information is confidential if you consider it to be confidential. But going back to a point I think Lee alluded to before, don't label everything as confidential if it's not confidential, because if you label everything as confidential, if you then get into a dispute and everything's labeled confidential, it's going to work against you, because the court is going to look at that and say, well, you're simply putting that label on everything carte blanche. And so label the stuff that is genuinely confidential. You need to protect as confidential, not everything. And that's the case for physical files. If it's stored physically in a filing cabinet, put a confidential label on it, or put it in a different color, whatever it may be, to identify it as confidential, as well as the electronic information. So protecting regulating against downloads is on there. That's an obvious one, and again, it's already been mentioned. As I said, we've all dealt with cases where people have downloaded databases, customer databases, and walked off with them. So there's things you can do to protect against that. Again, as Lee mentioned before, there's software that you can put in place that will alert you to unusual activity in terms of downloads of significant amounts of data, and that can go to your IT manager, and alerts can be set up to do that. You can even put protections in place to just prevent certain information being downloaded in the first place. You can put systems in place whereby people can't use their own USB sticks. It's got to be a USB stick that's provided by your IT department, and it just won't work. Because obviously that's an easy way for people to do things. They just put a flash drive in and download the information and walk off with it.
It's very common.
Yeah.
So even now, it's people still. I mean, people still do it. And we have case examples where, that sort of a little bit of knowledge is dangerous, isn't it?
Yeah.
That emailing to yourself. That's what that often happens.
Yeah.
And also downloading in that way.
And again,
really
the emailing is a really common one. We come across it so often that an employee is suddenly email things to the private email. And again, you can put there are tools available that you can put into your work email system, software tools that will either prevent that or alert you to it. So they're easy to put in place. Very common things nowadays. So that's something that you need to be looking at. Access as well. In terms of that, obviously make sure that anything that's of a business critical confidential nature is protected in terms of access. So limit access as far as you possibly can, password protect it, encrypt it, and limit access to the key trusted individuals who actually need to see that information. And finally, it mentions sharing on the slide. Obviously, make it clear to those people who do have access and you have granted access to, that sharing that information outside of the trusted circle, if we can put it like that, is strictly forbidden, and it shouldn't, and it's a serious issue. And that can be reinforced in terms of your policy documents and your contractual information and everything else. So you can reinforce it in your key policy documents, such as data protection policy is an obvious one. Most companies now, if you don't have, you should have one in place, an IT, email, internet policy that deals with these sort of issues as well. And again, the message can be reinforced in that type of policy. Codes of conduct, again, make sure you reinforce the importance of these issues there. And in your disciplinary policy, again, make it clear that this type of breach, if you breach confidential information, sharing when you're not authorised to do that, is a really serious matter, potentially constituting gross misconduct. So you're reinforcing it in all your policy documents so that nobody can say, well, I wasn't aware of this, wasn't aware how serious it was. So they're all things that you should put in place.
And really useful summary there, and a reminder that, if you have difficulty and you haven't consulted us on your restrictions, but you have a problem, it's still worth picking up the phone, because there are a lot of tools that do need to be handled carefully. And I would say it, wouldn't I? But you do need a lawyer to help you with it. But there are still, all is not lost. There are still things we can potentially do.
But that's right. I mean, I had a case literally a couple of weeks ago where the client contacted me. Somebody had done the thing we've been talking about,
Yeah.
basically taken the database with them. There was nothing in the contract, no restrictions, no adequate confidentiality provisions. I just sent a letter saying you're in breach of the database regulations, with some fairly weighty threats contained within that letter. Asked for undertakings. All the information was back within a day with signed undertakings. So yeah, it did the trick, and that was based upon nothing in the contract, just on using the database regulation.
And so that there are some other tools. Although bringing the sort of pendulum back a bit, it doesn't stop them competing. It doesn't stop them tapping up your clients, your suppliers. It doesn't, and that often is, protecting the information, and then that bit, which we're going to come on to, is just as important. Because if you do sit down with us and you go through it like a lot of clients do, we can wrap people up quite well and quite reasonably. It has to be so, as we'll see, to really give you a lot of protection. If you have problems with anyone senior who poses a threat. So are you done for that, David?
Okay. Yeah, that's me.
Great, that's great, thank you. I'll move on to the next one. So, can we restrict employees when they leave? I think this is mine. So yes, we can, but it depends on various factors. So we've looked at the information you need to protect. We've looked at what you can do with that information during and after employment. David's looked at some additional tools if you're left a bit exposed, but also that would complement our sort of toolkit that we'd use to cause people problems if they are posing you a threat. Now, can we restrict employees when they leave? Generally, from going and plying their trade, that's the question we're asking here. So various factors need to be considered. The answer is yes, but so are they senior enough? So the more senior the employee is, particularly if they're a director, you've probably heard of fiduciary duties, etc., then the more senior they are, the more likely it is that we can prepare provisions that restrict their activities when they leave employment and enforce them as well. So again, I'm going back to that annoying phrase, they're not enforceable, they're not worth the paper they're written on. They are, but they have to be applied properly. And these are some of the factors that you need to consider when doing so. Types of information accessed, well, we've covered all that already, haven't we? If this is a senior employee and they've accessed lots of confidential information or even trade secrets, then we need to prepare restrictions, don't we? And we will be perfectly entitled to set out within the law, within the legal framework that we've got, some sensible restrictions to restrict their activities. One thing I'd add here as well that's worth mentioning is that the courts have to balance the individual's ability to apply their skill and knowledge versus your right as a business to protect your reasonable, legitimate business interests. So that's why these sorts of factors that I'm listing here are in play, because the more senior, the more access they've had, the more a threat they are, the more it's legitimate to enforce post-termination restrictions, which we're going to look at specifically in a second. Remember the conduct and breach. So if I prepare some well-drafted restrictions that are really enforceable, and as clients have come to me, you come to me and say they've left, they're competing, and I ask for the background, and then you admit that you assaulted them, or some, which I have had cases like that. There was an altercation, there was an assault, or there was shouting and swearing, or something that we had done where we didn't cover ourselves in glory, shall we say, and we committed a breach of contract. We can't rely on the contract; they're free. So remember that you can't go to the court if you breach your terms fundamentally, seriously. So again, if you're dealing with someone and it's getting problematic, which is often where that kind of thing happens, come and get some advice. We'll guide you through it to make sure you don't essentially lose the protection that you put in place. You've got to behave properly. Drafting and execution of the terms as well. We're going to go into the type of terms that we can use post-termination employment, post-termination of employment, but remember that they have to be put together properly as well. So not just the terms and the drafting in the right manner, which we're going to talk about in a second, but the execution of the document. So clients will sometimes have bit naughty, but sometimes have our restrictions. They'll reapply them to someone else, and they won't execute the document properly. They won't have it signed at the right time in consideration for the right agreement with the employee. So, for instance, on promotion, you need to be careful about how you execute a new document with restrictions in, making sure that there's been adequate consideration. You give them something in return for restricting themselves. And then timing and evidence. Again, I think we covered that just in terms of putting the documentation together properly. But also, if you are looking to enforce any restrictions, you need to be able to gather and investigate evidence, as we've talked about, to justify your ability to enforce the confidential information restrictions, for example. But also, if you're alleging breaches of those restrictions, there's a process you've got to go through. So that's the restrictions we're going to talk about on the next slide. You have to organise yourself quite carefully to be able to enforce them, which I'll talk about in a second. So we'll move on to the next slide. So here are the contractual tools. We said you can potentially apply these, but they need to be applied to the right person in the right way and in the right circumstances, as I touched on that previous slide. So what sort of things can we restrict? What sort of activities can we restrict when people leave? And again, this is fairly high level, but just give you a flavour. What I'd like you to take away from this slide is just the understanding of what kind of activity you can prevent, how long you can prevent it for, and particularly in what manner and what area will depend on the individual circumstances of the case. So non-dealing, so does what it says on the tin. So stops people, a provision prepared by us for your business that potentially prevents an individual from engaging direct with customers, suppliers, and referrers. Really quite powerful. They just can't engage with them. Quite useful. Non-solicitations, that's selling essentially to some of the above customers, for example. Non-poaching of staff. So often I've seen it over the years. I think we all have collectively within the team where one person will go, they'll warm the seat, they'll start bringing other people across. So there are provisions to prevent that sort of poaching of key members of staff, but also teams potentially as well. All of these have to be put together really, really carefully. Just saying you can't take our staff isn't enough. It has to be at the right level of employee, but also it has to be at the right level of staff that you're restricting as well. With all of these, they have to be applied to the right person and in the right context. You can't just have, as I've seen before, a set of standard restrictions in a handbook that applies to everybody, 250 people within the business. It's just not going to work. Non-compete, now that is a little bit more difficult. So what we often go for is non-dealing, non-solicitation, non-poaching, and the non-compete tends to be very judiciously applied, because remember, as I mentioned earlier, it's a balance between the individual's ability to go out and practice their skill and knowledge versus the business's right to protect its legitimate business interests to a reasonable extent. Broadly speaking, that's the sort of balance we've got to strike. Non-compete is quite draconian in the sense that you can't work. You can't work in this sector or the industry that you've worked in. Now, if you're a very senior person, a director, again, lots of access, or a very senior exec in sales, really important to the business, critical, could cause a huge amount of damage if you left and competed, then it's more likely we could potentially get some sort of non-compete in place and enforce it. But it needs to be looked at quite carefully. As I've said on the slide there, it needs to be defined very carefully in terms of the areas of the business that the individual's been involved with. That might be geographical, it might be in terms of service or areas that they've sold in or worked in. Needs to be applied very, very judiciously, because the courts will look at that very carefully. Another really powerful tool to use as well is garden leave. Garden leave is a generic phrase. You could call it any kind of leave, but what is it? It's a period where the individual, let's say they're on 3 months' notice, you can send them home and you can require them not to engage with staff, with customers, and they sit there out of the sector. They're still employed, so they still owe you all those duties that Sean mentioned, duty of good faith, etc. So they're tied up both in implied and express terms, and that period there will block them out essentially. Well, it gives you I find with clients it's really useful because it gives the client a really good period to manage the person out of the relationships, manage new people into the business relationships. And even I've seen clients getting that person, as they're required to do, they're an employee, to attend meetings occasionally, to introduce people to new people, making it much more difficult for them to actually compete with you when they leave. And that's something we do help with, and I've helped clients with, is it's not specific on the slide, it's a practical point, but applied with legal knowledge, is managing an exit properly. You know, often business owners or leadership teams will panic, get the lawyer in, it's all negotiated, off they go on garden leave. But there needs to be a really careful plan about how you hand that work over. And if you can use that person, you have powers and tools implied and expressed in your contract to use them to make sure they do hand it over, rather than sticking them in a cupboard for 6 months and they reappear, and it's much more easy for them to approach your customers. As opposed to them being involved in a handover. And so additional contractual protections as well. So we can also look at delivery of provisions. So going back to some of the information that David said there, we do incorporate in senior exec terms obligations on exit. There's usually a provision in our terms around delivering all sorts of information, passwords, social media accounts. We won't get onto that now, complicated area, but you need access to certain things there, documents, information, making sure that they protect, organize, and deliver up in an orderly fashion all of your information to you in your contract of employment. Remember, if they don't do it, they're in breach of contract, which is helpful for us to pursue them. Sometimes you can have things like clawbacks of bonus provisions when they're on notice. That, again, more complex area, but we do deal with that too. It gives you a bit more teeth when people are going, and helps you with the timing of it as well. To share restrictions with prospective employer, that's something else got to be drafted carefully, but we often include warranties, legal promises, essentially, that they will essentially disclose what they have and haven't done, but also they'll disclose the restrictions to any new prospective employer, so that you don't get into a common situation where the new employer doesn't know about these restrictions. The individual's got a competing job, and then we're all fighting over these issues. Whereas if they were clear at the start, there could have been some dialogue and a deal sort of negotiated to allow parties to move on. Final point, we build into the contractual terms that we draft here is obligation to signed undertakings that they are complying with them. Often when somebody's left and a client calls us and says they're in breach, they're competing, one of the key tools, I think David touched on it earlier, is we'll all do it, where we will say to the client, look, there are possible reliefs for you at court, injunctive relief to stop them, etc. They are extremely expensive and time consuming, but we can do them, and they're very effective when we get them. But what we can do, first of all, is send a pretty heavy letter outlining the legal basis for the action, the contractual terms, etc. If it's all there, some of the evidence, will be strategic about that, requesting that they sign undertakings. If we prepared the service agreement for the director, or the contract for the head of sales, or whoever it might concern, it will probably include an obligation to sign legal undertakings, which is helpful because they're already on the hook contractually to do that. Good. Okay, so we're going to move on now to next section. So this is we're going to run through a quick common scenario for you. And this is where you get to see Sean, David, and I possibly argue over various ways of approaching it, hopefully. We don't mind that. So I think if you can stick with this presentation now, I think, and we found with clients and other people we've spoke to and delivered this sort of workshop to, because this is the basis of a workshop type presentation, it's been useful for them because you see it in practice. So if you two are happy with me, I'll run through this, and then we'll go through. We've got a set of questions on the other slide, and we'll go back and forth and answer them for you. So this covers a lot of things that you might come across if you're a HR director or manager, or you're in a senior leadership team who gets the hospital pass of dealing with this problem. And we often get this on the phone. Employee we just put X as a regional sales director. She raises grievances of bullying against our MD. She then resigns to work for a direct competitor. We discover that she downloads our regional customer database and emails it to her personal email account. The competitor is now contacting our key customers and suppliers. She has offered a role. To one of our senior sales team. She's causing chaos, as you can see. In her role, she has had access to customer, supplier, product pricing and marketing data. Her contract issued during her employment after her promotion, remember timing and execution that I mentioned, contains non-dealing with any customers for 12 months, non-solicitation of any customers for 12 months, non-poaching of any of our employees, and non-compete with any areas of our business for 18 months. Okay, so I think what we'll do then is just bear that scenario in mind. What we've got here is a sequence of questions, but it might be worth us actually, what we'll do is we'll go through the first question and then we'll come back. So will the grievances that have a bearing on whether or not we can stop her activities? If everybody's okay, I'll answer that one fairly quickly because I dealt with that on my slide. Is that okay?
Yeah.
And you two can argue with that answer if you want, but I think this is fairly non-contentious. And the answer is yes. So remember the point that I mentioned, that if somebody has done something wrong in the business and you come to us and say we want to enforce these restrictions, well, if they have materially breached their obligations to the employee, generally speaking, employers have to be reasonable with their employees. If they breach that fundamentally, they might not be able to rely on the restrictions in the contract. So that's a warning. Be careful on that front. Who would like to take the next question, David or Sean? Shall I throw it out and see you two?
Yeah, sorry, just on that first one,
Yeah.
I suppose one point just to come back on that. On that. It obviously impacts upon any contractual protections you've got in place, but again, going back to the database regulations we referred to, and in this case, it is essentially theft of a database we're looking at. Then the employer could, in that situation, rely on the database regulations still. So there would still be some, but the contractual, depending upon whether the bullying is made out, etc. But that potentially impacts upon the contractual obligations, because the contract could effectively have been destroyed by the MD's activities. But you can still fall back on the
extra
database.
tools that you described, which aren't destroyed by your bad behaviour. So you could assault each other and still use the database protection rights, which is what they would say.
Very useful.
And then I think it also it's just important, that David touched on, is just because she raised grievances doesn't mean that there was any actual bullying
at this stage.
It doesn't mean that she wasn't just doing it as a tactical grievance,
which
ploy.
People often do.
So I think the point, from my perspective, is not to sort of just assume, because she raised a grievance, we can't then enforce. That's not the case. It would only be not possible to enforce the clauses in the contract if there had been a fundamental breach, which would require a reasonable degree of evidence, I would suggest, of bullying by the MD. So that's one point. Also, I think there's a question mark over, even if there had been some bullying, even if that meant the express provisions could be argued to be not enforceable. But what about the implied term? Duty of loyalty and good faith, leaving aside any other arguments about the crime and the but does the breach, does the fact that the employer has breached the contract, whilst it may remove the express clause, but does it take away the implied duty of loyalty and good faith?
My view would be that if it's a repudiatory breach, it's a repudiatory breach.
And if it can take away the implied
the contract is destroyed.
And therefore
it goes to the heart of it,
also,
isn't it, by its very nature. I told you, everybody, if you did stick with this, we didn't let you down. We'd have a little row over.
It's more of a question, because I was thinking, what would happen to the implied term?
I have seen cases where there was a timing issue over that, but I think I'm with David. And fundamentally, if it's there,
struggle to then use the implied term. You fall back on the other.
So, next question: can we get our data back, and how would we do so? I think that's one for you, David. To be fair, isn't it?
and the short answer is yes. I think in this scenario, because it's if you look at the factual case that's outlined there, she has downloaded our regional customer database and emailed it to her personal account. So that's a fairly blatant breach, obviously, of her contractual provisions. But bearing in mind what we've just said about the bullying allegations, we may not be able to rely on those. So, but the database regulations we certainly can rely on, and we would be able to get our data back. Hopefully, if we act quickly, that's a point we'll come on to later. Speed is important here, but if we act quickly, we may be able to get the information back before she's been able to do a significant amount of damage. Although in this scenario, I know it says they're all contacting our customers, so some damage has been done already. But yeah, we can get the data back. We can get, and we talked about some of the things that can be done previously, given the fairly blatant nature of this breach. I don't think we'd have any difficulty going to the court and getting a search order to enable us to access even personal email account, so that we can look at her personal email account and see exactly what use she's made of that information. So we should be able to get it back. But that, as I've said, that doesn't necessarily prevent the damage, because some of the damage has already been done. So.
Yeah, and if clients can provide us with material evidence to show that it's been transferred to a personal account, it often surprises a lot of clients that I've secured a similar order, and that being on the basis that the client, once they establish that breach, i.e. taking that level of information outside of their system, they're entitled to close the loop on it, aren't they? They're entitled to close that down. Where has it gone? And that search order doesn't mean you can trawl through anything. You're just looking for those parameters, aren't you? And you agree those parameters and carry out searches. So that's good. That's great. So next question, can we access her personal email? We'll cover that. Well done, David. Can we prevent her from working for a competitor? My view,
if the bullying did amount to a fundamental breach by the employer, well, I think then the answer is no. If it didn't, the answer still might be no, because the non-compete is very wide. It's a not compete with any areas of the business. First of all, well, why? Why is she not able to compete in any areas? Even businesses, areas she didn't even work in? Why not? Where's the legitimate business interest there? So that would be a big potential obstacle to overcome. And also the 18 months. Why do you need 18 months? I personally would be saying in this situation, I wouldn't be advising client to spend vast amounts of money going to court to enforce that one, is my answer.
It could. I mean, it could be enforceable, but it's looking unlikely because it looks wide. It looks very wide, and it looks a bit too long. A sales director, I would expect 9 to 12 months. They're very senior and could. It's important to emphasise could be enforceable, but the wider and less specific it is, and the longer it is, the less enforceable it is.
I mean, normally when you get these type of restrictions in contracts, I think the better drafted ones tend to have varying periods, and they'll have a shorter period normally for the non-compete, simply because that's the most onerous one, and the court is going to be very loath to enforce that because of its impact upon an individual's ability to make a living, essentially, and doing the balancing out that Lee was talking about before. So to have it longer rather than shorter seems slightly odd. In the absence, what we don't know is there might be a specific reason for it, but it'd have to be a very good reason. It's difficult to think of one why it would be longer, given that it's they can only protect a legitimate business interest, and arguably they've got enough protection in with the other provisions.
To the others.
Agree. Absolutely. Can we stop the key employee leaving? If we go back to that reference to the non-poaching of any of our employees, again, a bit too broad.
Too broad, isn't it? They haven't adequately defined what they're looking to protect. I mean, if it was a key employee very clearly defined, and they had a legitimate business interest in preventing those employees leaving and joining a competitor. And again, the other issue with that is on the example, there is no time restriction on it.
Yeah.
It says non-poaching of any of our employees. So
Exactly.
you'd have
Yeah.
to be limited for a period of time, I think. as
Yeah,
well.
that looks
So,
a little bit,
Yeah,
looks like
difficult.
dodgy drafting there, we would
Yeah.
conclude, potentially.
yeah.
Yeah, and then last one, can we prevent her from poaching any more employees? I think we've essentially, forgive me. I blurred the answer to that one actually. So the first one was, can we stop the key employees leaving? I think the answer is probably no, unless we have restrictions to stop them from going somewhere specifically. We can't stop them leaving.
No, I don't think you can ever stop a
No.
person deciding to resign.
No, of course not. That would be a bit draconian. But then we've answered the next question, which is, can we prevent the employee? Can we prevent her from poaching any more employees? We could do if the provision was drafted properly.
Yeah.
That's a bit of an
Yeah,
own goal again,
yeah,
isn't it? Yeah. Okay, brilliant. All right, so that gives you then a flavour of how we approach these things, and just bringing some of those scenarios and issues together. You've got, remember, just to summarise, you've got the ability to protect confidential information, but it has to be the right kind of information, treated in the right way, protected in the right way. And there are wider tools outside of that David's explained that we can help you with. And you can, if your drafting is put together properly, potentially protect your customers, suppliers, staff, etc. for a decent period of time. But again, all of it needs to be looked at sensibly by qualified lawyers like us who are specialists in this area, so that it's organised in a way that gives it the best chance of being enforceable. Word of warning, remember, don't breach first, as we've said before. If you're finding it difficult with a particular senior exec or director, come and get some advice as soon as possible. We're on the end of the phone. We're happy to take initial ex gratia calls just to sort of check things out for you when it's for any of this kind of work. Restraints can be enforced. That's the other reminder I'd like to add. So forgive me, I've just started on David's slide, so he'll tell me off, but I'll pass over to David on this section. So restraints can be enforced if, David.
Yes, and we've got the key points to bear in mind on the slide there. So if applied carefully in the correct role and level, which is really reiterating what Lee was talking about there, make sure that you look at what you're trying to protect. It's got to be a legitimate business interest, and it shouldn't go any further than that. And so don't apply it carte blanche to everybody. Look at the individuals you need to have these protections in place for, and make sure, moving on to the next slide, make sure it's drafted properly by a skilled lawyer, and there is a which is hopefully come across, bearing in mind some of the things we've been talking about here and the problems with enforcing these things if they're not drafted properly. There is a lot of skill and thought that needs to go into doing these things properly and drafting them properly. So get it done properly. And it gives the temptation always, and I've come across it a lot. The temptation is to draft it too widely, and I've come across lots of employees who say, I want it for too long, and that's really shooting themselves in the foot because it doesn't work. So it's a mistake to draft it too wide. Then the same applies not just for restrictions but for confidentiality provisions as well. So if you label everything as confidential, again, as I mentioned before, the likelihood is that nothing's going to be confidential if you label everything as confidential. So make sure you draft the confidentiality provisions and put the specific things that are genuinely confidential, rather than, we've all seen the standard confidentiality paragraphs that list everything under the sun, most of which isn't confidential, and even cover it with the words like including but not limited to. So again, it just makes it so wide that it's difficult to really enforce. So some thought and skill needs to go into that. Contracted in the correct manner. We're quite brief on that because we've already dealt with that. Really, make sure the contract's signed, and make sure that if you introduce new restrictions on employees partway through employment, make sure that they're adequately dealt with in terms of consideration. I mean, often it's in line with a promotion, and there's consideration there because you're getting the promotion, you're getting the pay rise, you're getting the increasing status, but in return, you're recognising that you have to be subject to more restrictions because you're in a more senior position. So just make sure they're dealt with properly, and often they're not. So it's surprising how often we come across cases where there hasn't been adequate consideration, therefore they can't be
Very
enforced.
frustrating.
Yeah. So and enforced at the final one's important as well. Enforced at the right time by a skilled lawyer. Speed is important with these things. So if somebody does leave and take information with them and are damaging your business, you need to act quickly. If you don't, particularly if you're looking to get an injunction and restrict them from carrying on with that activity, speed is of the essence, time is of the essence, because the courts will look at it. They won't look favourably upon it if you've delayed to any extent, and you've potentially been deemed to have waived the breach. And also, if you can only get an injunction if you can establish that damage isn't an adequate remedy. A court is less likely to be convinced by that the more you've delayed. So that's important. But injunctions, as Lee mentioned before, aren't the only. They're difficult, they're risky, they're expensive, and unless you've got very clear grounds, you may not want to go down that route. But often, as we've alluded to, I think all three of us have talked about the effect of a well-drafted letter. If you send a powerful letter citing the right provisions, you can often get an employee to comply, a former employee to comply and sign undertakings without the need and the expense and the risk of going to court. And just one final example on that, while we're talking about it, as well as getting signed undertakings, another tactic that can be quite effective is sending a letter to the new employer if they've joined a competitor to put them on notice that you consider the employee to be in breach. And then it's not done that frequently, but it can be quite a useful tactic to do that and then leave it for a few months, use that time to gather information about if you've got evidence that there's an ongoing breach and they are damaging your business, gather that information, gather the evidence. You've already put the new employer on notice that there's been a breach. You can then potentially go for the new employer that normally will have deeper pockets than the employee. You can go for the new employer to say that you essentially induced a breach of contract here. We put you on notice, you carried on with it. We're now going after you for damages or an account of profits. An account of profits is where you basically you're looking to take the profits that they made out of that breach, which is often easier to compute. But again, you need to be careful with that. You need to be careful going back to one of the earlier points about not breaching first. It's more difficult to get that sort of remedy if you've behaved badly, because it's an equitable remedy, account of profits. And if you haven't, you've got to go with clean hands. So you have to be careful in terms of your own conduct. So,
I've also seen that example that David cites there as actually awful for the individual, but if the individual has done wrong and is doing business, quite a useful outcome. I've seen the new employer jettison the individual because the individual hasn't been honest.
It's true.
And they don't want anything to do with any tortious inducement to breach. In which case you've caused mayhem for the individual, which is really what you want to do because they've got no platform to compete with you as well. So it can also be useful for that reason as well.
Absolutely.
So hopefully, we're just wrapping up now. We've just gone over the hour, but hopefully if you watched us over lunch or at any other time convenient to you, that was useful. We try to share as much useful information as we can. We are all on the end of the email or telephone, so if you want to get in touch with us, do. If you are a present client, as ever, just give us a call. The team are very approachable. If you are a prospective client with an issue like this, we are careful on what we do in terms of free initial calls, but we will do initial consultations on things like this. It matters that you get in touch quickly and you get some advice. So if you're having these problems or you're anticipating them, then do feel free to do so. Thank you for listening.
Thank you.